items. Try to take them in order of brevity. I see that we have the Cordoba case for imposition of sentence. I don't see either Ms. Rumley or Ms. Millinan. All right. Any sightings of Mr. Millinan at this point?
Not yet, Your Honor.
All right. We'll recall that. The Goff case is a plea agreement and motion to set aside no contact order.
Yes, Your Honor.
Are we ready on that?
Dominic Rural in record number 19 CF 1102-21-426.
And for the state? All right. Ready to proceed on both sides?
Well, Your Honor, I was made aware this morning that Ms. Goff has two cases. You know, would recall, was made aware just a few moments ago that she's not going to be putting out the dual case. So I've submitted it. So unfortunately, that means that we need to remove that case from the score sheet. I just put in the request to do so. It has not committed. Sometimes it takes time to get that done. So I can continue checking for it. At this time, I don't have that. I don't have this score sheet.
All right. So Ms. Goff is now present on 21 CF 426. And this was apparently scheduled, Mr. Lucarelli, for two purposes: a plea agreement and a motion to set aside no contact order. What is your understanding as to what will occur today?
Judge, I think we're going to proceed to the 19 CF case. Public defender representing the Goff on the 21 CF case. She's chosen to go about this way. We met with her on Friday. We don't think it's in her best interest to do that, but she wants to do that and get out and see where the other case lands.
So are both matters in the same case or in different cases?
Different cases.
And the state now has a score sheet issue that it has to revise?
Yes, sir. I have to revise the score sheet to remove the 21 CF 426 case. And that one will have its own score sheet, and this one will have its own. And that does, I just did that maybe 5 minutes ago, was when I learned that both cases were not going to plead. So it takes a little bit of time to be able to get that done. I expect that I'll have it done this afternoon, but I couldn't tell you on how.
Judge, and I apologize. We met with Ms. Goff on Friday afternoon. Bill and I met with her on Friday. We spent an hour there at the jail. I thought we were close to resolving both cases, but today she wanted the weekend to think about it. She just told us a few minutes ago on the back that she's not ready.
So does the state need additional time before we address either matter?
Yes, Your Honor. With an accurate score sheet as it is.
Are we able to address it this afternoon or on a different date?
Your Honor, I believe we could do it this afternoon.
All right. Mr. Khalil, any comments?
No, Your Honor, I'm not available during the afternoon, but I believe Mr. Lucarelli can handle the resolution of his case.
All right. So is there going to be any witnesses presented for the motion to lift no contact?
Yes, Your Honor. I believe she thought the court was at 9 o'clock. She determined that it was 1:30, so she's not here again. I'll have to be continued to another date.
Okay, so that's not the person sitting behind you there?
No, Your Honor.
Okay. So we're not able to go forward on a no contact motion?
Correct.
You're going to reset that?
Yes.
Okay. What that leaves then is a plea agreement on one of the two cases?
That's correct, Your Honor. Just for the record, the 21 CF 426 case, which is going to be the one that's not putting out, because the defendant has rejected that offer is now gone. There is no offer in that case at this point.
Okay. So on you're confirming at this time, Mr. Lucarelli, then that will be the way we'll proceed then?
Yes, Your Honor.
And we'll recall the one case as requested this afternoon whenever the state has the score sheet ready. As far as the no contact order, that'll need to be reset. The case that is not resolving by plea, do we want to set that for a pretrial or case management?
Yes, Your Honor.
Okay. What is requested by the defense? I'm not sure what stage we were at with the case before.
Your Honor, I believe we were at the case management. We wanted to address this no contact order before we set it for trial. And so at this point, we were at the case management.
Okay. What is the next case management, Madam Clerk?
July 15th.
Is that adequate?
Yes, Your Honor.
state agrees to that date?
Yes, Your Honor.
And that's for which case number?
21 CF 426.
All right, the other case, and that case that we set for case management, the one that has the no contact order motion, that will be reset by Mr. Khalil.
Yes, Your Honor, we'll coordinate with the state here on this.
Okay. And Mr. Lucarelli, you're able to wait until the state is already on the score sheet? Anything else? All right, we'll recall Ms. Goff then when the state is ready. Which then brings us Mr. Khalil and Mr. Ashby to State v. Morris, 19 CF 353. And this is a motion to suppress. Are we ready to proceed on this?
Yes, I do have to say that Mr. Morris is not here. I propose that we take the testimony of the witnesses that are here, and then address his actions afterwards.
Okay. And the folks that are in the courtroom now are none of those folks?
Correct, Josh.
Okay. And the state is ready to begin, Mr. Ashby?
Yeah, I think we should address the defendant after this first, not here, he's supposed to be here. I think this should be a pretty quick motion, as he's.
Is the defense waiving his appearance at this time?
Yes, Your Honor. I mean, he has to testify as well, but we would request to waive his appearance.
Are you aware of any circumstances affecting his attendance?
No, Your Honor.
Okay. There are witnesses for the state and defense waiting?
Yes, Your Honor.
All right. Mr. Ashby, what's your position on the defendant's non-attendance?
Big position, Your Honor, this is a motion to suppress. I would something that it would also is not a written waiver and the file for a motion to suppress or for him to not be present for a motion to suppress. This is a key juncture in the proceedings. Furthermore, if the defense stated that they intended him to be here to testify, I'm not going to just supplant him in once he decides to join us.
I think I'll be deciding without his testimony is what it looks like.
You may very well be, Your Honor, since the petition that the state requests a bench warrant for his non-appearance.
Now, Mr. Morris actually has a pretrial conference tomorrow, is that right?
Yes, Your Honor. Your Honor, he hasn't missed any court dates. We've maintained adequate communication. This is unusual for him. I'm not sure why he's not here, but.
Well, the state's motion for a bench warrant is denied. We will proceed with the hearing at this time in his absence. Any preliminary comments?
No, Your Honor. They can go straight at it.
All right, you may do so.
United States at this time called code. And state in the book.
All right, Mr. Khalil, do you have witnesses present? If you could instruct them, please.
Yes, Your Honor.
All right, Madam Clerk.
Clerk, and raise your right hand and be sworn in.
Do you solemnly swear affirm the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
I do. Please have a seat for witness box.
Good afternoon, officer. Welcome.
Your Honor, before we begin, I believe the gentleman, you have court? Yes, or? Yeah. Okay.
Next moves out, I will take it.
Can you go back to the clerk and the first option, the first board, that we have court?
Mr. Rosado, I don't believe I have him on the docket this afternoon. Madam Clerk, are you able to determine if Mr. Rosado has a court date? Do you have a case number, Mr. Rosado?
I did get I go downstairs and get it for you.
Let me just see if the clerk can find out.
I did one court date, they got to send it for this one. For the next.
For what day?
What's your first name, sir?
Alexis.
Alexi?
That name does sound familiar, right?
Yeah. Today's the 78.
Oh, I'm sorry.
All right. See you tomorrow.
Now we know you know.
Okay. All right, without further ado, Mr. Ashby.
Thank you, Officer. Good afternoon, officer. Can you please state your name for the record?
Corporal Matthew Pacoli,
Thank you, spell your last name, sir.
P is Peter, CC, both I.
And sir, how are you employed?
I work for the Collier County Sheriff's Office.
And what are your duties with the Collier County Sheriff's Office?
To enforce all state statutes and traffic violations within the county.
And how long have you been with the Collier County Sheriff's Office?
June will be 7 years.
Were you with the Collier County Sheriff's Office back on February 12th of 2019?
Yes,
You had an opportunity to interact with an individual by the name of Brady Morris.
yes.
Sir, and what was the nature of that interaction?
I came in contact with Mr. Morris during a traffic stop where he was ultimately arrested for narcotics.
Now, what was the basis for the traffic stop?
Stop sign,
And where did that stop sign violation occur?
Larson,
And do you know the intersection?
Larson by Pine Ridge.
Sure, Your Honor, in the record, I'm showing defense counsel mark the state's exhibits 1 and 4.
Yes.
May I proceed with this, Your Honor?
Yes.
Corporal, I'm showing you what's been marked as state's exhibits 1 through 4. Do you recognize it?
Yes,
And what do you recognize in that?
this is the Spinnaker area. This is where I came in contact with Mr. Morris.
All right, starting with state exhibit 1, is that a fair and accurate depiction of the location?
Yes,
And state exhibit 2, is that also a fair and accurate depiction of the area where the traffic violation took place?
yes,
Same with state exhibits 3 and 4?
yes.
Yeah, state moves into state exhibits 1 through 4 and evidence.
Defense
No.
admitted.
Corporal, looking at the not come to a stop sign.
All four wheels did stop. He just stop sign and go.
And is there a stop sign on that at that intersection?
Larson and Pine Ridge, yes.
Now, state exhibit 1 is the intersection. What is the intersection of Larson and Pine Ridge? Is that correct?
Yes,
In your report, you stated that there was another street intersection where the interactions to the traffic stop took place. Is that fair to say?
yes.
What was the reason for that?
I'm not familiar with the area. I was getting confused by the street names. At that time, I didn't know that W. Morrison, W ran this way, Morrison ran the other way. I wasn't sure.
So was it that you're familiar with the physical layout, but not the names of the streets?
Correct.
Is that the reason for why then you did it? You got the intersection of Larson and Dudley?
Yes,
So let's talk about Larson and Dudley. Is there a stop sign on Dudley?
on W, yes,
If you, and Dudley and Larson intersect at a T intersection.
correct.
Now, looking at, I believe it's state exhibit 2, if I'm not mistaken. If the defendant wished to turn right onto Larson, is there a stop sign there?
Yes,
And if he does not come to a stop sign, obviously that's an infraction.
yes,
Looking at state exhibit 3, if the defendant wished to turn left onto Larson, is there a stop sign there?
yes,
And if the defendant does not stop there, that's also a violation?
correct.
Looking at state exhibit 4, that shows the Larson and the spinning crane, is that correct?
Yes.
Now, what is a spinning crane?
It's been great. It's a motel.
Is from state exhibit 4, is that a picture from their driveway?
Correct.
Is that a public or a private driveway?
It's private.
And from your recollection, was the defendant leaving out of the spinning crane?
He may have. I know he was within the W area.
Now, if you leave from the spinning crane, would he have to stop before entering onto Larson or Dudley?
Yes,
Now, the defendant was turning from, you said the defendant committed the driving infraction on Larson and Pine Ridge.
correct.
Where did you eventually pull the defendant over on?
It was on Pine Ridge, right by 75.
So where you pulled the defendant over was on Pine Ridge.
Yeah, it was on.
Now, is there a stop sign coming from Pine Ridge onto Larson?
No.
And Larson after, or Larson dead ends into the Spinnaker end.
Correct.
Oh, and sir, did all the defense face closing car court?
Yes.
The question this time around.
Cross-examination, Mr. Khalil?
Yes, Your Honor.
And Your Honor, permission to use this as just a display. It's not evidence. I just want to be, so that the witness can interact with the map. This is, Deputy Piccoli, is this an accurate description of the area?
Mr. Ashby, any objection, or do you need to move?
I've moved on, I've not seen this map that defense counsel is.
This is a live feed from Google Maps.
Any objection?
Not.
And so, Deputy Piccoli, just to back up a little bit, how familiar are you with this area?
Not really at all.
Okay, all right. And so, in your booking report, which intersection did you say that you saw Mr. Morris come out of?
Well, to be fair, I'm having a hard time reading this map. I'm not too familiar with the area, but it was the Dudley Drive area.
Okay, so would it be
General
like
specific.
east and west?
I couldn't give you specifics on that.
Okay. Looking at this map, is Dudley depicted east and west?
I'm not sure.
Okay. Where's Larson Way?
Looks like it's right there.
Hey, you're on permission to have the witness step down and point to Larson Way?
Yes, you may step down, officer.
And so where's Larson Way? Okay. And where's Pine Ridge?
Okay.
And where's Dudley?
Looks like it's right here. So,
Okay. So in your booking report, you stated that he had ran a stop sign on Dudley, is that correct?
yes.
Okay, and it's your testimony today that he actually ran the Larson Way stop sign.
Correct.
And where would that stop sign be?
Right in front of Pine Ridge.
Okay, and where's Pine Ridge?
It's up here.
Okay, all right. You can ask me.
Thank you.
What time did you make this stop?
21 to 43 hours approximately.
Okay. Do you remember where the defendant's vehicle was?
In regards to
What road was he on?
when Larson.
He was on Larson. Okay.
Well, when he committed the infraction, correct. in Pine Ridge.
Okay, all right. And he failed to stop at a stop sign?
Yes.
Now, you would reference Spinnaker Inn at a point. Do you know if he was ever in the Spinnaker Inn at any time?
I know he was in the Dudley area, which I know is by Spinnaker.
Okay. And where did he eventually come to a stop?
Pine Ridge by 75.
Now, do you remember taking a deposition in this case?
I do.
And the deposition was on July 7th of 2020?
Yes.
And in that deposition, obviously, you're sworn to tell the truth, the whole truth?
Yes.
Now, we're talking about the intersections that was ran. And where the stop signs were located.
Mhm.
Now, I even had shown you a map. Do you recall that?
No.
Okay. So This is the map that I had showed you. It's very similar to that one on July 7th. Does it recall, do you recall at all?
No.
No? Okay. I had also shown you a panoramic of this exact intersection. Do you recall seeing this?
Well, I recognize it from this.
Okay, all right. So you do remember seeing a panoramic view then?
Yeah.
Okay. Now, when you took that deposition, you were trying to answer those questions as fairly and accurate as possible.
Correct.
And on page 3, line 19 through 26, I'll just go ahead and read those. It said, okay, so I'm going to show you a map here. Answer, okay. Question, if you could please point or just mark on the map where you saw the defendant and where you were. Oh, I don't remember that. I don't know exactly. I was more positioned so on in this place. In lines on page 4, 15 through 21, you said, okay, I'm sorry, the question was, he was leaving Spinnaker in? I don't recall. Question, you don't know if he was actually leaving Spinnaker in or out on the road? Well, in fact, I know he was on Dudley Drive. Is that correct?
Objection, Your Honor, improper impeachment is not presented with any conflicting statement you made.
Objection sustained.
Would you admit that in your deposition, you had said that it was Dudley Drive?
Yes.
And you said it was for a fact that it was the stop, that he ran the stop sign on Dudley Drive.
Well, during the time, I didn't really know the intersections, but yes, I would say that.
Okay, all right. So is it your testimony today that you clearly and accurately remember the days of that stop?
Yes.
And so, again, during your deposition, you had stated on page 3, 23, in regards to marking the map where you were, I don't exactly know where I was more positioned so on in this area.
Objection, improper impeachment, again, different.
Sustained.
You wrote a booking report in this case?
Correct.
And what date did you write that booking report?
February 12th, 2019.
Was that the day of the arrest?
Yes.
And is it fair to say that you recall the events better on that day than you do today?
Yeah.
No further questions.
Redirect.
Corporal, you acted extensively about the discrepancy between your booking report and your testimony of today. Did you learn more about the names of the intersections between the date of your booking report and deposition today?
Yes.
And based on that and your review of what you know where the infraction took place, did that alter your understanding of the name of the street where these infractions took place?
Correct.
Where did the infraction take place?
Larson in Pine Ridge. Stop sign.
Which street in Pine Ridge?
Larson.
Larson?
Yes.
Going back just a little bit, Larson, Dudley and Pine Ridge, they run parallel to each other, is that correct?
Correct.
They're fairly close to one another?
Yes.
Larson, a very long street?
Yeah.
So, fair to say that, what is on Larson? What, is there any landmarks on Larson that you're aware of?
Yeah, you have, I believe it's Shell and Big Burger King.
And from your recollection, when the defendant ran a stop sign, where was he located between?
Those two buildings.
Now, on Dudley, What is on Dudley as a landmark on Dudley?
Spinnaker.
Now, is there a hurricane in the shell on Dudley?
No, it's more Morrison.
No further questions, Your Honor.
Anything else for this witness?
Yes, Your Honor. One quick question. When he turned onto Pine Bridge, which way was it going, east or west?
What was the question again, Counsel?
When he ran the stop sign on Larson Way, when he turned on Pine Ridge, was he going east or west?
And the objection?
Outside the scope of the redirect.
Objection overruled. You may answer.
I don't know east and west.
Okay.
No further questions.
Anything else, Mr. Ashby?
Let's further consider.
Does the witness need to remain for either side?
Not for the state.
No, Your Honor.
Officer, you're free to remain or leave as you wish.
Thank you, Your Honor.
Additional state evidence?
State complex.
Any defense evidence?
Yes, Your Honor. At this time, we would like to call Chris E. Shirley.
Okay, if she can be summoned, please. What's the name again?
Chris E. Shirley.
Okay.
Shirley, Shiley.
Separate this way, please. You face the clerk and read your right hand, each one in.
Do you solemnly swear or affirm to give the truth, shall tell you the truth, the whole truth, and nothing but the truth? Yeah. Okay, thank you.
Please have a seat in the witness box. Watch your step.
Hello, Ms. Shirley, welcome.
Hi.
Please be seated. Thank you for your patience waiting. Mr. Khalil, when you're ready. Do you need the podium moved, Mr. Ashby?
No, fine.
Good afternoon.
Hi.
Could you please state your name?
Christy Shirley?
And do you remember the night of February 12, 2019?
Yeah.
And was it dark that night?
Yeah.
Was your vehicle stopped by the police at all?
Excuse me?
Was your vehicle stopped by the police?
Yeah.
And could you tell us about what happened? Why was your vehicle stopped?
We were going into, I guess we're making a U-turn into this motel area. And we made the U-turn and we came back out. And that's when the police pulled us over.
Okay. Now, were you on, so if I could just use this map, this is the Spinnaker Inn down here.
Mm-hmm.
This is Dudley Drive. This is Larson Way, and this is Pine Ridge. Do you remember what road you were on?
When we got pulled over,
No, when you were making the U-turn.
we were making the U-turn in the complex,
Okay,
in that motel area.
so
We went in there and then we just turned around and went up.
were you in the Spinnaker Inn then?
Yeah,
Okay, and were you heading out to Pine Ridge?
yeah.
Okay.
We just went in there and we turned around and then we were heading back.
Could you explain a little bit better?
What do you mean?
So when you were making a U-turn, did you make it out on the road or did you make it in the complex of Spinnaker?
In the complex at the Spinnaker.
Okay, and then after you made that U-turn, where did you guys go?
We went to Pine Ridge Road.
Okay, so what stop sign was ran at the point of the infraction?
There was no stop sign that was ran.
Okay, and could you explain where that stop sign was located?
Well, we got pulled over on Pine Ridge Road,
Okay,
which is ways from the hotel. And there's no stop sign right there.
right where?
Right at Pine Ridge.
There's no stop sign on
No.
Pine Ridge?
Mm-mm.
Okay. Do you know if there's a stop sign at Spinnaker Inn?
Yes.
There is a stop
There's
sign.
a stop sign somewhere, but it's not on Pine Ridge.
Okay. So the basis for the stop, which stop sign was ran, according to you?
There was no stop sign that was ran. We stopped, and then we went to Pine Ridge. There must have been something going on at the Spinnaker Inn because there was police there, and there was another guy on a walkie. They were probably doing some kind of raid or something, and then followed us out, thinking we were part of it or something. But there was no stop sign that was ran.
Okay, all right. Did you see the police officers before they turned their lights on?
No.
Did you see the officers when they initially turned their lights on?
Did I see them when they turned on their lights?
Yeah, so you're in the car, the officers turned their lights on. Did you see when they initially turned their lights on?
When we were on Pine Ridge Road.
Okay, so you were on Pine Ridge Road when you saw the officers?
Yes, and we stopped right before the I-75 sign
No
on the
further questions?
right-hand side.
No further questions, John.
Cross-examination?
Briefly, Your Honor, Madam Clerk,
Yes.
please state Exhibit 1. Madam Clerk, what is your?
Yes.
Ma'am, I'm showing you State's Exhibit 1. Do you recognize me yet?
Is this a newer picture? I don't know where this is.
You don't recognize State's Exhibit 1?
Is that Pine Ridge?
That is, State's Exhibit 1 is showing the intersection of Pine Ridge and Larson. Do you not recognize it?
Yeah, now I see. There
You
was
see-
no stop sign there though.
You said, it's your testimony today, there's never been a stop sign on Pine Ridge and Larson.
I don't remember a stop sign. It was further back near the hotel.
No further questions, Your Honor.
Anything else?
No, Your Honor.
Does the witness need to remain for either side?
No, Your Honor.
Thank you. Have a good day. You're free to leave if you wish, or remain as you wish. Any additional defense evidence?
No, Your Honor.
Any state rebuttal evidence?
No, Your Honor.
I'm sorry, Your Honor, we would like to call Mr. Morris, but he's not here, so we would not press at this time.
And when do you propose to call him?
Your Honor, tomorrow, if we can address it.
I don't think so. It's set for today. There's been no excuse provided for his non-attendance. This is the time to be set for hearing, and the evidence will close today if there's nothing else to be presented.
Okay, yes, Your Honor, you can proceed to argument.
Go ahead, as the moving party, Mr. Khalil.
Your Honor,
Can I see the exhibits, Madam Clerk? Thank you. Okay.
But I guess the first issue is which stop sign that he ran. The defense was going to put on evidence that he ran the Dudley intersection as indicated by the Booker report and the deposition of the deputy. That would be the first issue. Did he run the Dudley stop sign or did he run the Larson and Pine Ridge stop sign? The second issue would then be to interpret the statutes. Was he required to stop at that point? And in the defense's motion, we referenced statute 316.123, the right of way at an intersection may be indicated by a stop sign, yield signs authorized in section 316.006. That statute is then going into the county's jurisdiction over all of the city or the county streets and highways in their ability to place and maintain traffic control devices. There is no stop sign when you're exiting Dudley Drive. If the court is to take a position that he in fact ran the Dudley, the exiting of Spinnaker Inn onto Larson Way, in that intersection, there is no stop sign. And when you're coming into Spinnaker Inn, as the deputy had indicated, there's also no stop sign. Mr. Ashby had indicated that it's a dead end, but the defense's argument is to facilitate the economy of Spinnaker Inn. Traffic can come in freely and traffic can leave 2.3. In those state exhibits, it does show a speed bump. And when you're approaching a speed bump, when you're driving, it's to slow down, not to stop. And if you look closely at those photos, one of the speed bumps is yellow. It looks like the incoming speed bump, indicating that they had replaced it. And when they had replaced that speed bump, they had never added in a stop sign. When someone is maintaining that road, they never noticed that there's a stop sign missing if the county wanted to put it there. Also, on the intersection of Dudley, there appears to be a stop sign that is temporary. It doesn't have a pole and a sign attached to the top, but instead it's on the ground, and it kind of has a makeshift stand, indicating that the county realized that there's no stop sign on the intersection of Dudley and Larson Way, and so they had put a stop sign there because they realized they made a mistake. Interestingly enough, they never added a temporary stop sign to Dudley and Larson Way because they had wanted to facilitate the economy of Spinnaker Head. Based on all the factors, we would ask the court to grant the motion to dismiss, grant the motion to suppress comment.
Mr. Ash?
Yes, sir. I'm going to approach the case closed for your review. State would ask you to deny the defense's motion to suppress this case for because the stop of this case was a lawful traffic stop. Starting first with obviously the officer specified in State's exhibits 1 through 4. You see a multitude of stop signs. Specifically, starting with State's exhibit 1, we see that there is a stop sign on Pine Ridge and Larson Way. The officer testified that the traffic infraction occurred on Pine Ridge and Larson Way, and that the defendant, he did continue to commit the infraction, and then the officer stopped him on Pine Ridge. That testimony was consistent that he was stopped on Pine Ridge on his way near to the I-75 on-ramp. And the officer also addressed the issue of the Larson-Dudley confusion. It's not an area that he patrols frequently, and he missed the name for the traffic infraction, namely that the traffic infraction occurred on Larson and Pine Ridge, not Dudley and Larson, as he stated in his report. He questioned extensively on that, and he explained it was simply a scrivener's error and a mistake on his part that he missed the correct street, correct intersection for which the infraction took place. He corrected that and testified as such. So what we are left with is the testimony here today is that the defendant ran a stop sign and that is a valid basis for a stop. Starting with 316.123, subsection 2A. Except when directed to proceed by a police officer or traffic control signal, every driver of a vehicle approaching a stop intersection indicated by a stop sign shall stop at a clearly marked stop line, but if none, before entering the crosswalk on the near side of the intersection, or if none, then at the point nearest the intersection roadway where the driver enters a vehicle approaching traffic on the intersection roadway before entering the intersection. After having stopped, the driver shall yield the right of way to any vehicle which has entered the intersection from another highway or which is approaching so closely on said highway as to constitute an immediate hazard during the time when the driver is moving across or within the intersection. So, despite the defense's argument about the county's facilitation, I guess, of Spinnaker Inn, the temporary or permanent nature of the stop sign, at the end of the day, if there's a stop sign, drivers shall stop. It's not up to the driver of the vehicle to determine what stop sign they want to stop at, what stop sign they will stop at. They have to stop at a stop sign, no matter where it's placed, whether it's on Dudley, Larson, Pine Ridge, I-75, there's a stop sign, you have to stop. Your Honor, defense brought up the Spinnaker Inn and went into this testimony about the defendant left the Spinnaker Inn, specifically in that case of the dead end Larson Way, dead end into the Spinnaker Inn. In 316.125, vehicle entering highway from private roadway or driveway or emerging from an alley, driveway, or building. Subsection 2 States the driver of a vehicle emerging from an alley, building, private road, or driveway within a business or residence district shall stop the vehicle immediately prior to driving onto a sidewalk or onto the sidewalk area extending across the alley, building, entrance, road, or driveway, or in the event there is no sidewalk area, shall stop at the point nearest the street to be entered, where the driver has a view of approaching traffic thereon, and shall yield all vehicles and pedestrians which are so close thereto as to constitute an immediate hazard. As the defendant, even if despite there being no stop sign on leaving the Spinnaker Inn, pursuant to Florida Statute 316.125, the defendant has to stop before entering, when leaving the Spinnaker Inn, a private driveway, before entering the public roadway of W Drive or Martian Way. Your Honor, however, again, as noted, the officer's testimony today is that the defendant committed a traffic infraction on Larson Way and Pine Ridge. He ran that stop sign as is shown in State's Exhibit 1 on Larson Way and Pine Ridge. As you see in State's Exhibit 4, that the Spinnaker Inn is a private residence. It has speed bumps. It has a sign posted showing that it is a business. It is specifically a hotel, and that the area with the roadway that ends most notably by two large yellow speed bumps. In State's Exhibits 2 and 3, you see the stop sign on Dudley Avenue. In any way or form, the defendant had to stop the stop signs. It did not matter.
One moment, Officer Harrison, it's been several times now that this lady has been heard interrupting the proceedings, so she needs to be removed until she's ready to be called. She's being disruptive.
First.
Sorry, Mr. Ashby, we'll wait to resume. It's been more than once. All right, go ahead, Mr. Ashby.
Thank you. Again, so, Your Honor, the state also included, based on how the motion was written, the defense may go into a different direction as far as their questioning. This state did include Colony State 696, Southern 2nd, 757. That is a Florida Supreme Court case stating that going for the objective basis, should the court be aware that when applying the objective test, generally the only determination to be made is whether probable cause existed for the stop in question. The state put to the court that there is probable cause that the defendant ran a stop sign, and we also observed that. The state also included State v. Davidson. That's merely that is included in the court's packet. The court largely probably disregarded that as again in anticipation of where I believe the defense was going to go with the questioning. That is more so saying that approaches on the live on, but that obviously come up in this case. But Your Honor, for the reason stated in the evidence presented, the state is of the position that the court should deny the defense's motion to suppress. The officer clearly indicated the defendant ran the stop sign at Larson and Pine Ridge. Admittedly so, he made an error as to the name of the street where the intersection traffic infraction took place, and he admitted as such on stand, which goes to his truth and veracity when he can admit his errors. However, it is not an error that he ran a stop sign at Larson and Pine Ridge, and for that reason, Your Honor, the state actually denied the defense motion because there was a lawful traffic stop and there was a lawful basis for the traffic stop.
Mr. Khalil, a rebuttal?
Yes, Your Honor. In Florida Statute 316.123, it states that every driver of a vehicle approaching a stop intersection indicated by a stop sign shall stop at a clearly marked stop line. There's three elements there. Approaching the stop intersection, we would have to assume that this Dudley and Larson Way intersection is a stop intersection. Indicated by a stop sign, there's no stop sign there, and clearly marked by a stop line. But if none, that's the critical words. But if none, does that refer to the entire statement or just the stop sign? And it's the defense's position that it only refers to, it refers to all three of those elements instead of just, is there a stop sign there? But if none, then this section will apply. The defense would concede that section 316.125 does apply, where this is the stop sign section. Where if you're exiting a private road or driveway within a business, then the vehicle shall stop. It then goes on to say, but if not, then you have to stop at either the sidewalk, but if none, at the nearest to the street to be entered where the driver has a view approaching the oncoming traffic. So we can see that that one would apply. However, it's an indirect conflict with section 316.006, where we go into that jurisdiction again. The county has the right to maintain and control traffic. They have the right to place traffic control devices where they wish. Then it becomes a statutory interpretation at that point. And because this statute is a higher statute, the defense would argue that this one should apply instead of the later statute, 316.125.
All right, thank you. The evidence presented is as follows. Corporal Matthew Piccoli, the stopping and arresting officer in this case, 7-year veteran of the sheriff's office, testified that while on duty, he encountered the defendant, Mr. Morris, and his passenger, who was Mrs. Shirley. Officer Piccoli said he stopped the vehicle for a stop sign violation at an intersection. The state then has introduced into evidence 4 photographs of the area, which I believe have been taken subsequent to the events in question.
Yes, sir. Or during. There's dates at the bottom.
December 18. Well, there appear to be different dates on here. December 18 and June of 16.
And Your Honor, if I can help, the defense will concede that's a fair and accurate representation of the intersection. We were going to introduce the same photos.
Of all of the intersections?
Yes, Your Honor.
Okay, thank you. So those are the state's exhibits. Officers, I understood Officer Piccoli's testimony. He said that the 4 wheels of the vehicle did not come to a complete stop. He testified there was an error in the report as to the streets involved. He clarified that the traffic violation of failing to stop occurred at Larson and Pine Ridge. The probable cause affidavit filed in this case indicates that it occurred on Dudley Drive. On cross-examination, the officer was asked about this contradiction. He said he was not familiar with the area. He was firm in his position, correcting himself that it actually occurred at Larson and Pine Ridge. He says that the actual stop with emergency lights occurred on Pine Ridge near I-75. Officer was confronted by Mr. Khalil on cross-examination with some of his testimony at a prior deposition. The officer did admit some lack of recall. He did admit that at the deposition he described the violation occurring at Dudley Drive. He went on to further testify that he recalls the stop today, that he wrote the probable cause affidavit on or about the date of arrest. On redirect, Mr. Ashby asked the officer about this contradiction between the probable cause affidavit, the deposition, his testimony here in court today. He said that subsequent to the deposition, he had learned the names of the intersections more thoroughly, and that he recalled certain landmarks near where the violation occurred. The defense presented Ms. Shirley. She was the front seat passenger, according to the probable cause affidavit at the time of the stop. Ms. Shirley says she recalls the events. She recalls a U-turn into the Spinnaker Motel, coming back out, and was stopped thereafter after they had emerged from there. Ms. Shirley was definite in her comment that there had been no stop sign violations. On cross-examination, well, she said she did not see the police before the emergency lights were activated, and that occurred while on Pine Ridge. On cross-examination, Ms. Shirley stated that the Pine Ridge and Larson, she did not recognize that photograph initially, but stated after she was explained what it depicted by the state, she, as my understanding, insisted that there was no stop sign, at least at the time of the events. Counsel, does the court's recollection conflict with any of the counsel's recollection of the evidence?
No.
Okay. Essentially, there is a credibility issue here. The court, as do juries, considers how the witnesses testified, what they said, and how it appears to line up with the totality of the known evidence presented so far. Ms. Shirley has some interest in this case, although she is not charged. She was apparently associated with Mr. Morris in some degree. The officer admitted to his lack of recollection. He says that after further examining the intersections that he doesn't recall the events and that the violation occurred at the Larson Way and Pine Ridge location. Other than the officer's general interest in law enforcement, there's been no specific motive identified for this case, while this officer would either would not be telling the truth in this situation. At this point, the officer has less interest in the matter than the defendant or the person associated with him, and the officer did say he had corrected his recall. There is clearly stop signs in the area, and in particular at Pine Ridge and Larson. Ms. Shirley's testimony is diminished slightly by the fact that even when shown the image of Larson Way and Pine Ridge, she still disputed that there was no stop sign at that location. So the credibility nod goes to the officer. The court finds that based on the credible testimony from the officer, there was a lawful stop. The motion is denied. Any other clarifications, counsel? All right. We'll see the defense and Mr. Morris then tomorrow at pre-trial conference. Have you waived his appearance in writing on that, Mr. Khalil?
Not in writing, Your Honor.
All right.
I don't think he anticipated being here, but we require his.
All right. If you could either find out the circumstances of his non-attendance today, see if you can procure his attendance tomorrow, or find out if there's something preventing him from attending that's a legitimate excuse, I would entertain that.
Thank you, Your Honor.
All right. Madam Clerk, do you need a written order for purposes of the hearing?
No, good.
All right. They might be helpful, Mr. Ashby, if you would just do a generic order, just indicating that the motion was heard and denied, and that the reasons set forth in the court smart recording of the oral ruling with findings.
Yes, sir.
All right.
Your Honor, may I approach the?
Yes.
Thank you.
And Officer Harrison, do we know if or Mr. Lucarelli, is the lady that was asked to leave, is she part of your case?
No, I believe she's part of the Diamante case.
Oh, the Diamante Mole case, all right.
Yes.
Then Mr. Samato and co-counsel, I'm sorry. Sorry. Sometimes the names overwhelm me, sorry. Let's take a short break. If you'll let Mr. Khalil and Mr. Samato and Ms. Horowitz, if you'll let me know when you're all set to go. And then the person can return to be in the courtroom.
Okay. All right.
All right. Brief recess. Oh, I'm sorry, we do have the golf matter. I
No,
forgot.
I'm not, I'm just gonna let you know that was for Mr. Cleo's, the case, the golf matter. The case that Mr. Cleo was representing, that's Mrs. Taylor.
Okay, so she's not on the Diamante.
She's not on that.
Okay.
Oh, okay.
Are we ready to address golf now? Or let's address golf then before the break, and then we'll focus on Diamante Mall.
I'm gonna set up either way.
Two brothers working from the. Should I ask her to come back in?
That's fine.
That's my mistake. I thought she was with Demonte.
Would you like to hear the no contact order while she's here, or should we just take the plea and then have that readdressed?
Are we able to address both, Ms. Mason?
You can address both. Your Honor.
All right.
Ladies, can you please put your mask up over your nose? Thank you.
All right, we'll resume with the Goff cases now. And which is the case we're calling both of them, or just
Yes.
one?
Your Honor, first we'd like to call 19 CF 11.
All right, Ms. Goff is now present. So which case is being called first, the plea?
Yes, sir.
And which number is that?
1102.
Okay. And Mr. Lucarelli, you're representing her on the plea agreement?
Yes, Your Honor.
All right. There are no competency issues affecting the entry of the plea?
No, sir.
All right. And Ms. Goff, please, you can remain seated. Just raise your right hand and be sworn. Thank you. May lower your hand. Please answer the state's questions. Well, first, let me find out what the terms are.
Your Honor, it will be an adjudication of guilt, 9 months in jail with credit for time served, followed by 24 months of state probation. There'll be a substance abuse evaluation, follow all recommendations. The defendant will be subject to random drug and alcohol testing at her expense. The standard no alcohol provision. Court costs, $100 cost of prosecution, $368 cost of investigation to the Collier County Sheriff's Office.
Public defender? No charges on this case. Any, Madam Clerk, 100 prosecution, what are the court costs?
We paid $450.
Okay. Mr. Lucarelli, any objection or request for hearing any monetary amounts?
No, Your Honor.
Okay. Any clarifications on the plea agreement from the defense?
No, sir.
Ms. Goff, do you understand and accept these terms?
No.
Mr. Lucarelli, are we able to go forward at this time?
She seems to be a little confused, Your Honor. She's insisting that there was a time where it was 6 months. We offer an ounce of those.
There was never a 6-month plea offer. There was a jail offer and there was a prison offer.
Yeah. And I think it was, the confusion is that she has a lot more credit in this case that I'm representing her on than Mr. Cleo's case. And I told her to be closer to getting out of my case than she would in the second case. And that was, we were trying to get the state to reduce it to 6 months, but that was not happening, and she's still on that 6 months.
So at this point, what does the defense wish to do? Is the state's plea offer being revoked if not accepted today?
On the 21 CF 426, yes, and on that case alone, Your Honor, I do have the sentence, but she scores a minimum of 18 months in prison on that case alone.
So, Mr. Lucarelli, the defendant does not seem ready to go forward. Do you want to take a recess at this time?
Let me talk to her just to make sure she's finished.
2 minutes.
All right. Let me take a short recess, come back, and then let me know if you wish to go forward or not. Is the defense seeking to go forward either way on the motion to lift no contact,
Yes,
or are they interlocked?
it may be a global resolution depending on how this conversation goes, but
All right.
we intend to go forward with the motion to lift the contract.
All right, we'll take a 5 to 10 minute recess and see where we are.
All rise, court is in recess.
Sorry, I know we submitted the order for the motion to suppress. Is there any?
Right, I signed it.
Oh,
Judge Foster.
I won't let him get started without you.
I'm sorry?
I won't let him get started without you.
I will be fast.
Okay.
All right, sir.
oh, no, this is part of the season seven. They I would assume this section. How fast the next section? The one thing is locker. The rest of us are just here.
Then you should practice. No, see, it's not there for you.
That's the music. That's the music. That's not the music.
I didn't know there was a conversation.
Well, we have a secondary solution. Probably should have been already. Project recovery, she does project recovery, send it down to your fees. She's probably gonna get it for 7 weeks, I think it's a month. She's got 4.5 months to do the interviews.
That's because we got 45 people.
You know that. I didn't even know that. It is drug court. For mental health.
That's something that would be important, whether she's will be done.
I don't know. Right, you were used to that.
Besides the last name suggestion. The dog family and the drugs. Yeah, that's that one.
Tammy, it was separate one, could have been Tammy, and then put it in.
What is this stuff?
It's supposed to be, I think I don't think so. I think the whole point of your agreement. So you never, when it comes to passport, I think.
All right, well, when you're in the
This one's 3 hours fresh. No, that was it. That's all we got. This one. We got a 2 hour tea, and they get their documents. Yeah.
Now,
Some point in time, where are we staying?
some point in time, we'll look at this one.
I was in the stream.
This is part 6.
Part me, when I was in it.
And then part 4 will be after that.
Where's mine?
He's not here, the first one she was away.
She's okay, I don't think it's anything negative. Mine, I mean, but mine first.
Well, you want like that?
I think it's 9. Oh, sorry. Everything
But
is
it's not like anything going through. That's what. Because I thought rain also.
Yeah, when you pointed it out, I was like, oh crap, the brain issue.
Yeah, that's a big issue.
I think it's a cataract. I don't know anything about that. Complicated. Yeah, I would think not, but.
I wasn't. Good, I haven't seen you in the flesh in about 3 years.
Yep. So that, I mean, I don't think it's gonna, I got like 10 questions, 15 questions. I don't know if it's gonna be anything revolutionary.
I don't believe this is a good validation for you.
I don't think so. But it is, maybe it's good as I need to get mine. Sorry? Yeah, I mean, she's gonna be, yes, yes. I just want to. Yeah, need to file a motion to stay upon. Explain that that's almost crazy.
That's almost crazy.
Oh, that is, I mean, you know, I just can't do that.
You can't find that everywhere.
You ever done a one collar case?
When was the peak? I mean, not to this extent, but, there's a kid, and actually, actually, one kid tried to find small, like, he was so, I mean, so many credit cards, and he said that, I mean, yeah, they're complicated, but you enjoy tracing money, I think that, I mean, you know, like putting pieces together, you know, that's what I'm saying. Yeah, exactly. But not to this guy.
The mentality is different.
Yeah, that's interesting, yeah, Mike was saying that, yeah, I don't know, I mean, yeah, I would agree with that. But also, sometimes the sophistication, I mean, she should, yeah, a lot of things that we have to go over, like, was not confusing, like, what?
Right. You know.
Sure, yeah.
That's wrong.
Sure, yeah. That's not always an easy one.
That's true.
I hear you, but no, I understand what you're saying. Yeah.
You guys need the evidence that was admitted last time?
The evidence that was admitted.
No, I'm not 15 right.
So she was in cross, when we spoke to Janet Apple, she said that when she looked at the list there, she spoke to the person, she said she could do the two-time office.
You ever
They
seen a
don't have any
documentary
records
on
since 2008.
Netflix?
So either
fraud or McDonald's, you know?
No.
No, but I can agree.
Yeah, it's interesting.
It was very interesting. It was interesting how my husband was like, you know, I just really.
What was most interesting is that McDonald's was very okay with the, because they were making, their goal was still cheap, but they still made money. That's what they wanted.
It's been on there for a long time.
It's a great document. I was very fascinated by it.
Only
One million dollars.
Whenever you are.
How's the call? Are we ready to meet the whole thing right now?
Well, either way,
Yeah, you can go up and wait. How come it?
You making your own videos?
I do.
I have nothing else to do. Why don't you put in a tiny flag in the corner or something? Oh, celebration flag.
Yeah, there we go.
All rise, Collin County Circuit Court is back in session.
Welcome back. Ready to resume, Mr. Crowley?
Yes, Your Honor.
All right, let's have Ms. Goff join us. Thank you. Please be seated.
Mayor, you need to have your Can't tell you again.
If there's another violation, she will need to be escorted out. So you had a chance to confirm, Mr. Crowley?
She understands, Judge, that her confusion was that, and Judge, when you asked earlier if I think there's any compensation, I don't think there's a compensation, but she does suffer from severe anxiety when she gets going. It's hard for her to clearly remember things. And she was confused about the amount of time she had left, and she thought that she was almost done, and not sure she came out for 6 months.
That you've clarified everything now?
She understands.
All right.
We had an attempt at another resolution to wrap up both cases with death row.
Okay.
So we're gonna take care of 19 CF 1102.
All right, Ms. Goff has returned after speaking in private with Mr. Lucarelli. And Mr. Lucarelli, how does the defense wish to proceed?
Yes, Your Honor. We're going to enter a plea, withdraw not to the no contest to the charges in case number 19 CF 1102.
With the plea agreement previously announced,
Yes, Your Honor.
the other case is left unresolved.
Correct.
Any clarifications from the state?
No, Your Honor, I think the only thing that does need to be clarified is that although she's doing a 9-month jail followed by 24 months of state probation, that probation doesn't start until she's released from custody. So if she's still in custody on the other case, her probation is not going to run while she's in custody on the other case still.
That is, of course, standard, Mr. Lucarelli.
I just want to make sure that she's aware.
You start your probation when you get out.
Yeah. No, right, yeah.
Ms. Goff, after speaking in private with Mr. Lucarelli, do you wish to accept these terms?
Yeah, I get it,
Okay. Please raise your right hand and be sworn.
Do you solemnly swear affirm to evidence you shall give the truth, the whole truth, and nothing but the truth? Yes.
Thank you. May I lower your hand. Please answer the state's questions.
Would you state your full name and date of birth, please?
Ron Gonzalez, 823, 1959,
What are the last 4 digits of your social security number?
5087.
Have you ever been known by an alias or any other name?
Yeah.
What alias or name was that?
Well, Wall was my maiden name.
Is it Long, L-O-N-G?
Wall, W-A-L-L.
Well, okay.
And Salinas was a married name. And Nelson was a married name.
Have you ever been arrested under any of those names?
No.
Where were you born?
Key West, Florida,
And how far did you go in school?
the 12th grade.
Are you able to read, write, and understand the English language? Are you under the influence of any drugs or alcohol today? Are you prescribed any medication?
I am.
And is that a medication that you take at night or do you take it during the daytime?
Both.
Okay, and have you taken that medication as prescribed?
Yes.
And does that medication impact your ability to understand what's going on today?
No.
Does it impact your ability to make decisions?
No.
And as we said here today, do you feel that you're thinking clearly and able to make a decision about your cases?
I am.
Are you suffering from any kind of mental condition or disorder?
No.
Do you understand why we're here today?
Yeah.
And case number 19 CF 1102, you're charged with 1 count of introduction of contraband into a county detention facility. It's a 3rd-degree felony. It's punishable by up to 5 years in state prison. To that charge, you plead guilty, not guilty, or no contest.
No contest.
You understand by entering your plea today that you're waiving your right to a jury trial on that case?
Yeah.
And at that trial, you would have had the right to see and hear the state's witnesses testify, to have your lawyer question them, the right to subpoena your own witnesses and submit evidence on your behalf, the right to testify or to remain silent, the right to make the state prove this charge beyond a reasonable doubt, and the right to have a jury determine whether you were guilty or innocent. Do you understand your waiving those rights?
Yes.
Counsel, have you reserved any matters for appeal?
No.
Ms. Goff, do you understand that you're giving up your right to appeal anything other than whether this court has the jurisdiction to impose this sentence?
Right.
I'm showing you a plea of guilty or no contest form. Do you recognize this?
Yeah.
It has your name and your case number here at the top. It's front and back, and there are 2 signatures here on the back. Are those your signatures?
They are.
Does one of those signatures indicate that you've read this form or that it's been explained to you and you understand all the rights contained in it?
Yes, ma'am.
Did you have the opportunity to review this form with your attorney?
Yes, ma'am.
Did you have any questions about it?
Yes, ma'am.
I'm also showing you your score sheet. Your score sheet shows that you have a total of 71.1 sentencing points. The maximum sentence you could receive on this charge is 5 years in state prison. The lowest permissible prison sentence on this charge is 32 months in prison. Do you understand do you agree that this score sheet is accurate?
Yeah. Okay.
And while you score 32 months in prison, do you understand the state's offer in this case is to something much less than that?
Oh, yes, ma'am.
Do you have, has anyone forced you forced you or threatened you to get you to enter this plea?
No.
Are you entering this plea in your own free will?
Yes.
Do you feel that entering this plea is in your best interest?
Yes,
Are you satisfied with the advice and counsel of your attorney?
I am.
Has he done everything you asked and answered all of your questions?
He has.
Has he discussed this case with you in its entirety, including any possible offenses you may or may not have?
He has.
Counsel, have you reviewed all the discovery in this case with your client? Ms. Goff, is there anything about this case that you wanted the chance to review, but you have not had an opportunity to review?
No.
Your Honor, I'm not aware of any physical evidence to be tested for DNA. Counsel, do you agree?
I agree.
Ms. Goff, do you understand as a result of your plea today, there is no physical evidence in this case that would be tested for your DNA?
Right.
Do you understand that?
Yeah. Yeah, my fault. Oh, yeah, okay, right.
Do you understand that?
Yeah.
Okay. And do you also understand that upon completion of your jail sentence, that you're going to be placed on 2 years of probation?
Right.
And that probation is going to have certain terms and conditions. If you were to violate the terms of your probation, you understand that the court could, that you could be going back into custody and could be sentenced up to the maximum 5 years in prison. You're right in that?
Yes, ma'am.
Good. And Ms. Goff, I also just wanted to make it very clear that you do have a second case that's not resolving today, correct?
Yes, ma'am.
And that case is 21 CF 426.
Right.
Do you understand?
Can I have a moment, please?
Yes.
Are you okay? Are you okay? Are you under the influence of something?
No, I'm not the influencer.
Well, I think you better wake up and pay attention.
All right, ready to resume?
Yes.
All right, thank you. Ms. Mason, anything else to add?
And Ms. Dahlman, I know your attorney's gone over this with you, and I want to make sure that it's clear for the record that because the other case is not resolving, do you understand that you do score a minimum of 18 months in prison on that case?
Yes, ma'am.
And that if you were to be found guilty on that case, do you also understand that the court could then sentence you to a consecutive sentence, which means that it could run after this case? Do you understand that?
Yes, ma'am.
Okay. And is that your decision to resolve only one of the cases today?
Yes, ma'am.
Okay. Do you understand that if you are not a United States citizen, you may be subject to deportation or removal as a result of this plea?
Yeah.
And that if you were deported or removed as a result of this plea, it would not be a basis to withdraw your plea. Do you understand that?
What?
No,
I'm serious.
I understand. It's something I have to tell her.
I'm sorry, I got a little distracted there, I was on with you.
Okay. Do you understand that?
Yes, ma'am, I do.
Counsel, do you stipulate that the court may rely on the court file and the affidavits contained therein to establish factual basis of venue? And that venue is proper in Collier County, Florida?
Yes.
Ms. Goff, also, do you understand that if the offense to which you were pleading was sexually violent or sexually motivated, or if you had previously been convicted of such an offense, This plea may subject to the involuntary civil commitment as a sexually violent predator upon completion of your sentence. You understand that wording?
Yeah, right, but no, yes, I understand that.
Now, at this time, the state would ask the court to take judicial notice of the court file on case number 19 CF 1102, which has repeated the court. I'm hearing for the plea for and the score sheet.
Mr. Lucarelli, any other defense comments or requests?
No, Your Honor, just regarding the amount of time she got in.
Okay, have you calculated that?
162 days, Judge.
How much?
162, and I reviewed it with the station.
And that's based on jail information?
Yes, Your Honor. That's based on a
Okay.
May 3rd request. She had 127 days since that day, so it was 162.
Does the state have any objection to that credit being assigned at this time?
No, Your Honor.
So that will be granted and noted on the judgment and sentence. Based on the plea agreement, plea colloquy, the plea of no contest on this case only, the arrest affidavit, facts in support thereof, court accepts the plea agreement. As agreed, adjudication of guilt, 9 months, Collier County Jail, credit all time served at a minimum 162 days, to be followed by immediate reporting in Collier County for supervision for 24 months. Any need to transfer supervision, Mr. Lucarelli?
I don't believe so, Your Honor.
Conditions as announced, substance abuse evaluation and follow recommendations, random testing, no alcohol provisions, monetary amounts as previously described and not objected to are all approved. Additional?
She wants to make sure that there's no objection to early termination if she qualifies later on.
State have any comment?
Your Honor, the state has.
So there's no agreement on early termination, but Ms. Goff may request early termination upon successful completion of conditions, and typically at the halfway point, although that is not fixed completely.
We'll ask her.
All right, so this case is resolved. Mr. Khalil, on the other case, that's been set for case management, or do we need to set a date on that?
I believe it's already set, Your Honor.
And you wish to address the no contact order motion at this time?
If we have time, Your Honor, yes.
We can address it. Is the state objecting to the motion on no contact?
Yes, Your Honor.
All right, and what case number is that, Mr. Khalil?
21 CF 426.
All right, is there any evidence to be presented?
Yes, Your Honor. This time we'd like to call Glenda Taylor.
Ms. Taylor can come up, please.
Ms. Taylor, step right this way, please. Right this way, Ms. Taylor. Very good, watch your step. If you face the court, raise your right hand to be sworn in. We're good right here.
Do you solemnly swear or affirm the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
Ms. Taylor, would you please step in the witness box? Watch your step. I'll hold the first one. That's good. Let's sit right here.
All right, hello, Ms. Taylor. Mr. Khalil, you may question.
Thank you, Your Honor. Please state your name.
Glenda Taylor?
And you were listed as a victim in this case, is that right?
Yes.
And what happened on the night of March 12th of this year?
It wasn't a night. What happened is Rhonda and I got into a little argument about something, and she didn't hit me, but she attempted to. And it scared me, and I called the police.
Okay. Did she ever grab you in any way?
No,
Did she ever push you?
no,
Did she ever cause you any bleeding that night?
anyway,
Bleeding?
no,
Are you fearful of Rhonda? Are you fearful?
no, oh, absolutely not, no.
Do you require her assistance in any way?
Yes,
And could you explain what that assistance is?
well, she helps me with my house, my dog, my everything. She's very intelligent and does a great job helping me out.
Would you like to have contact with Rhonda Goff?
Yes,
Is anyone pressuring you to be here today?
no,
Is anyone pressuring you to lift the no contact order?
no,
are you here of your free choice?
Yes,
Are you aware that if the no contact order is lifted, you can always have it reimposed?
yes,
If something were to happen, would you call 911?
yes.
No further questions, Your Honor.
Any state questions?
Yes, sir. Ms. Taylor, you testified today that there was never any contact, physical contact with your daughter on the evening of this incident, is that correct?
There was never what?
Any physical contact? I believe you testified that she never hit you, she never pushed you, and there was never any bleeding caused?
None of those things, but there was contact. She grabbed my hands.
Okay.
But there was no bleeding or bruising or.
And do you recall, when law enforcement showed up, do you recall giving them a statement?
Yes,
And in that statement, you told law enforcement that your daughter did grab you by the arm. Isn't that right?
that's right.
And she tore your skin. Isn't that correct?
A little bit, yeah.
All right, Your Honor, the state has no further questions.
Redirect?
Yes, Your Honor. How were you ever injured by your dog?
Yes,
Objection, Your Honor, this is outside the scope.
It has to do with the source of the injury. Objections overruled.
Could you please answer the question?
yes, I have.
Okay. And which arm did you sustain that injury?
Left,
Your left hand? All right. And which arm did Rhonda grab?
left.
The left? Okay.
I'm left-handed, so I'm always out front with this.
No further questions, Your Honor.
Anything else from the state?
No, Your Honor.
Okay, thank you, Ms. Taylor. We step down.
What's your step, please?
Any additional defense evidence?
No, Your Honor.
Any state evidence?
No, Your Honor, sorry.
Arguments of counsel, beginning with Mr. Khalil.
Your Honor, Ms. Taylor indicated that she does need her daughter. She's here for free will. The incident, while she did admit that she did grab her, it's a little bit inconsistent in terms of the questions that I had asked her. She said that she wasn't pushed or hit. And at this time, we'd ask for the court to lift the no contact order.
State comments?
Your Honor, the state is concerned about this particular incident, especially, and then would also make the argument that Ms. Taylor didn't appear to be very truthful with the state's questions, Judge. She initially claimed that there was no contact, that she said that there was no touching, there was no hitting, there was no pushing, there was no bleeding. However, when the state did question her and confronted her with her own statement that she gave to law enforcement, then she admitted that the defendant did grab her and did tear her skin. The whole thing about the dog, Judge, honestly, that's not even the statement that she gave to law enforcement, so I'm not quite sure why that was even brought up. The statement that to law enforcement was that she was grabbed, that she was drunk, that she was grabbed, and that her skin was torn. The state has serious concerns about tampering with this particular witness. We would ask that that this case, that the motion be denied.
Any rebuttal?
No, Your Honor.
There is some reasons to question the credibility of the testimony I've heard. The dog involvement in this, and the dog is not charged with anything, but the dog mentioned was allegedly from the defendant. It looks to me like Ms. Taylor is conflicted in this situation based on the way she testified, both what I've observed as well as what she has stated. The injuries in this case are de minimis. The incident, never to understate any incident that is domestic related, but it is not on the aggravated end of the scale. Is there any history, Ms. Mason, with this alleged victim that the state is aware of with this defendant?
Your Honor, the state is not aware of any history with between this defendant and this victim. The defendant does have significant criminal history. However, I'm not aware have not had the opportunity or did not check to see if any of the previous criminal history involved this particular victim.
And looking at the score sheet for the other case for Ms. Goff, it does not show any violent history other than the only one that would be a stretch would be a burglary of a dwelling occupied, but that's not accompanied by any battery or otherwise. The rest are controlled substance and assorted charges that are not violent. There does appear to be a need to have support for Ms. Goff at the home, and Ms. Taylor does appear to be here of her free will. Ms. Taylor, you do not wish to have any restrictions on contact, is that right, Ms. Taylor? Do you want to have unrestricted contact?
Yes.
So at this time, the court will grant the wishes of Ms. Taylor and allow for there to be unrestricted contact from this point forward for the reasons I've commented about earlier. Motion is granted. All right, Mr. Simano, after that, Ms. Horowitz, after that meticulous effort to set up our connection, we've apparently reobtained it. I'm impressed how quickly you recovered and reconnected.
Mr. Jolly, can you hear us? We can hear you.
Okay.
Your Honor, I'll submit the order to you of the meeting space that just left, so.
All right.
I'll submit it to your office.
Okay.
Can you hear us, Mr. Jolly?
All right, we'll wait just a moment to finish the other case. All right, Ms. Taylor, the motion was granted. That case is finished now. Have a good day. Sign the print form. And next we have State v. Diamante Mole, and the parties are all present. I'll go ahead beginning with the defense to announce the appearances. And Ms. Mole is present. The state? Okay. And remotely connected, Mr. Samato and Ms. Horowitz?
Is Mr. Jolly, who is the victim in this case, Judge, he indicates that he cannot hear us, but we can hear him.
Okay. Is there any way we can improve the situation?
I'm working on that.
All right. I'll wait just a moment and see how we do.
Judge Link, we only have to follow one witness today. I know the rules, sequestration of previously walked after witnesses in the hallway, however, acceptable to state court, I can just have us in the back of the courtroom, unless further observe the rule, even with no other witnesses.
Let me wait till they're finished connecting. We'll address that.
Not even.
You can hear us. Okay. Thank you.
A preliminary matter, counsel, and this is, the case numbers are 17 CF 778 and 779. Preliminary matter for the state, Mr. Levy has asked if the gentleman that is here on behalf of the defense can he remain, or is, under the rule, are you asking him to wait outside?
Yeah. I just think there's the rules in both, but he's not, nobody else does.
We're going to be done when he's unpresent on this. The purpose would be either way.
So no issue, so he can remain. Okay, welcome, sir. And
The gentleman is present, folks, Mr. Mall.
Oh, I'm sorry, yeah, that is correct.
you're referring to someone else?
My witness is in the hallway, that's correct.
All right.
I'm sorry, maybe I should have clarified. While this was going on, I was going to ask Mr. John, our witness, but now it's, yeah, now it's on the hallway. Now it's good, now we can go back and I'm in a little bit.
Okay. There you go. All right, so if we could recap either side where we are. Mr. Jolly, can you hear the court at this time?
I couldn't understand the question.
Yeah, can you hear us adequately?
Not quite.
Okay, we want to make sure you can hear adequately, so let me see if they can play with the connection a little bit more.
Judge, I think we're as loud as we can get.
Right. Mr. Jolly, is there any improvements for you?
Yes.
All right, greetings and welcome back to this session to everyone. Let's resume. Counsel, Ms. Mole entered a plea to the bench in this case, and we did all of the plea colloquy on the last occasion.
I think it's too far.
All right, and we also addressed some motions. Was there any evidence presented at the last hearing? If you'll just refresh the court, please.
Your Honor, I believe that there were witnesses who were brought by the defense in regard to the defendant's character, and those who knew her from the church and they had the.
Oh, yes, okay, now, yes. All right,
But that's not complete, the state has not presented that.
all right, I do recall that now.
And the purpose for today, the next court date is on July 20th. And Mr. Johnson, witness for today, is not going to be able to testify on the 20th. We don't have time to accommodate the one witness so he can testify. I anticipated being relatively short. Between 10 and 15 questions asked. And we know the witness is today in the case will be continued until July 20th. Defense anticipate closing the
Is that the state's understanding of what is going to be taking place both today as well as at the July date?
As long as it's copied without motion.
I'm doing all of that.
All right, then at this point, are you ready for that witness?
Yeah.
Go ahead.
But then we call Peter Johnson, he's in the hallway.
Very well.
Trade a laptop.
Mr. Johnson, you can step this way, please.
No, you're in the court.
Wait, Mr. Simone, you got- Right this way, sir. You face the clerk and raise your right hand, please.
Do you solemnly swear or affirm the evidence you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Please have a seat on the witness box and your step.
Hello, Mr. Johnson, welcome. Thank you for your patience while waiting. And I think we're set to go. Mr. Levy?
Thank you, Judge. Mr. Johnson, good afternoon. Do you mind stating the name and spelling the last name?
Peter Johnson, and my last name is Johnsson.
Thank you, sir. Are you currently employed?
Yes, sir.
Where do you currently work?
St. Matthew's House,
And what is your formal job title?
Vice President of Development.
Please briefly explain what your duties and obligations as Vice President of Development.
Oversee fundraising and public relations for St. Matthew's House.
Thank you. Do you know the defendant in this case, Mr. Lamb?
Yes,
Do you recall when you first met Elaine Moore?
believe it was summer or fall of 2019, pre-COVID.
How was Ms. Mole involved with the thing?
She started coming to some women's lunches, prayer lunches that we had with women from our recovery.
Okay. Did she volunteer for St. Matthew's House?
Yes.
When someone volunteers for St. Matthew's House, they have a certain maybe prayer request. When someone applies to become a volunteer for St. Matthew's House, does the St. Matthew's House do a criminal background check on the applicant?
Yes.
were you aware of Ms. Mold's pending criminal case at the time she volunteered at the same time?
Yes.
And that did not disqualify her from work,
Not from that specific volunteer capacity that she wants.
Do you mind explaining what Ms. Mold did as a volunteer at the same time?
She leveraged her contractor connections to raise in excess of conservatively $75,000 worth of gifting kind materials to help with the renovation of a house where women in recovery would live and be unified with their children.
Did she have any other involvement in are you referring to the LIABLE property?
Yes.
That is a rehab facility for women?
Yes, sir.
Did she have any other involvement other than raising approximately $75,000?
She did, but that's the main one that I knew about. I think she was involved with helping in discipleship with the women, but I'm not that involved in the program.
Are you able to go into any detail regarding what approximately was raised as part of $75,000?
New roof, roofing labor, lots of materials, tile materials, cabinetry, from an array of contractors and big box stores like Lowe's, for example. We bought a property that was really adjacent to our existing women's recovery program. We bought a property where the house was unfit for habitation, and we wanted to be able to expand our program. So we had a major donor who was willing to buy that property and help us renovate it. And she certainly saved us, like I said, tens of thousands of dollars, if not close to $100,000.
And she raised in-kind donations, correct?
In-kind, all in-kind, no financial donation.
Correct. And all that was in the form of labor or donation. In other words, she was essentially an ambassador, almost an ambassador. She lobbied particular people in town to contribute that, correct?
Correct.
Were there any concerns from any or complaints from any of the donors that you spoke with that you became aware of?
None that I'm aware of.
Any concerns from the St. Matthew's House about as well as contributions or work as a volunteer?
None that I know of.
Thank you, sir. I don't have any further questions.
Any state questions?
Yes, Your Honor, thank you very much. Mr. Johnson, when exactly is the promise that you can see over there? May I speak from
That's
you?
fine. You want to just pull the microphone a little closer just so Mr. Jolly can hear?
Can you hear us, Mr. Jolly? Very good. Thank you, Your Honor. You made the podium a little lower. It was better for me. That's just me. That's it. So, Mr. Johnson, you indicated there was a piece of property that was purchased by another donor. Is that what Jill's house is now?
Jill's Place is a facility in Elba. That's a property that we acquired now about 4 years ago. There was an adjacent property to that, a 5-acre parcel that was purchased that had an existing house that was really unfit for habitation.
And that is the property that was purchased by another person, correct?
By a donor, yes.
And who is that donor?
Grounds, one moment, grounds,
Relevancy?
overall.
I'd rather not say.
Okay, did the donor request to remain anonymous?
Yes, they did.
Okay. So that said, once this purchase occurred, tell us how it was that the defendant became involved with fundraising for this project.
Well, she had been coming to the Jill's Place. We had lunches in Naples where they're just worship lunches, and she heard about this property being purchased. And we knew that her talents were in some sort of contracting network. And she said she thought she could get us gifts in kind. And so she started working with me and some of my colleagues in development to find specific, materials for what we needed. For example, the first thing we changed with the roof. We took the roof off and put a new roof on.
If I can just interrupt you, so you said that her talents were in fundraising. How is it that you knew her talent?
Her talent was she had a network in contracting.
And that's something she reported to you?
I believe so, yeah. I believe she and her husband did some sort of contracting work.
So you had no independent, pardon, I'm sorry, I spoke over you. So you had no independent knowledge that she had this particular talent in reaching out to contractors. That was something that her and or her husband conveyed to you?
Other volunteers also told me that was what her work was.
Okay.
Other women who came to this lunch, a lady who organized those lunches had also worked with her.
Okay, and that was information that you had in addition to the information of the previous steps that you gave the home.
Yes.
So it was not that she was working with other women to counsel them as far as you understood. As far as you understood, she was working to help you raise money?
No, she never raised money.
Okay, she was working to help you raise in-kind donations?
She was working to help us raise in-kind donations, and she was helping to counsel the women through worship.
I thought, pardon. Previously, you said that that's not information you had personally.
I said I know that she came to these lunches, but as far as her relationship in the cycling, I'm not privy to the personal relationships she might have had with women.
Okay, so your testimony is limited to just what she was supposed to be doing or was supposedly doing for St. Matthew's.
For St. Matthew's house, both raising gift in kind and coming to the lunch.
And did she, when is it that she first offered to provide that assistance?
Well, it would have had to been after we purchased the property, which was probably, think about that. I think it was near the beginning of COVID or even after COVID started. What was that, 2020, February 2020? Somewhere around there, I'm not exactly sure. It might have been a little bit before COVID started.
Were you aware of exactly what the charges are in this particular case?
I don't know if I could say I knew exactly. I knew there was theft involved. There were accusations of theft. I did know that.
Did you know that there was an accusation and that the defendant has since entered a plea for exploitation of an elderly person?
I didn't know that until later.
When later did you know that? Or was it after 2020, February of 2020?
I believe so, yeah.
And you said that you knew about her previous conviction, is that correct?
I don't know how much I knew about her previous conviction. I knew she was in legal trouble for that. That's about the extent to which I knew.
Okay. Well, that was pending, is that correct? That's what your understanding was?
Correct.
Information as far as what was pending. Now, you were asked if you ran a criminal history, or you did a background check.
Yes.
Okay. Who does that background check?
Our volunteer engagement team.
And what does that background check include?
I don't know. I don't do that.
So you don't, okay, so you have no idea how many previous convictions for theft she has?
No.
Did you ever ask her?
No.
So as far as this background check is concerned, it's just what they're facing right now?
No, ma'am.
Okay, so as far as Ms. Diamante-Mola is concerned, you didn't know what her previous criminal history is. Although there was a background check done, all you personally knew, Mr. Johnson, was that there was a pending allegation against you.
But I'm gonna make an appearance.
For clarification overall.
Could you repeat the question?
Yes, I can. So as far as your background check, the information that you, Mr. Johnson, had, it was limited to, there is a pending charge involving a theft right now.
I didn't do the background check. My volunteer engagement team did the background check. I get told by them whether or not a volunteer would be eligible to do the job that I may want her to do, or him.
Do you or somebody else determine eligibility?
Someone else does.
Okay, but you are providing the specific information regarding whether or not there is an issue as far as the background is concerned.
Sometimes.
Jack, that was asking.
Sustained.
Did you ever have a conversation with her regarding these allegations?
Jack, ask me. Just ask. You know, if they ask me, then,
Objection sustained.
When was it that you learned how many previous convictions you had?
I'm not sure I would have learned that. I would have learned that there were allegations of criminal activity, but I'm not sure I would have learned specific numbers.
So you were not aware that there are actually more than 10 convictions that related charges, is that correct?
Sustained.
Not aware of her priors in detail.
Sustained.
I have no further questions, Your Honor.
Redirect?
Let's just read it. May I address the table?
Yes.
Mr. Johnson, are you aware that there's a prior conviction or criminal offense to exclude someone from working the same act yourself?
No, we've got a lot of people who have criminal histories working in various capacities.
Are you also aware that in addition to the in-kind donations that were made, is there any repurposing of prior sequels or things like that?
Oh, yeah, of course.
Can you expand upon that?
Sure.
Question, Your Honor, that's beyond the scope of explanation.
It is appear to be beyond the scope, Mr. Levy.
I understand.
Sustained.
I have no further questions.
The state does not have any additional
Is
questions.
Mr. Johnson released by both sides?
Yes, sir.
Yes, Your Honor.
Thank you, Mr. Johnson. Have a good day.
Thank you.
Is this the limited purpose of today's hearing, Mr. Levy?
Yes, Judge, that was just, again, thank Your Honor for accommodating testimony for witness
Okay.
that is not available.
And to be clear, we have set the finish for the July date.
Yes, sir.
And how much time did we allocate for that?
I believe your office allocated the same amount of time as we originally had.
All right, let me just confirm that now so that we leave with a clear understanding of what remains. One moment. See if Officer Harrison can text my assistant. But while we wait for that, your understanding is 4 hours reserved when?
July 20th.
That's your recollection, is Mr. Levy?
Judge, I believe we're gonna have 2 witnesses, potentially 3 witnesses today by Mr. Hoffman. I think planning out the motion to whether we need to double check the issue.
So we already did that.
Starting on that.
No more motion.
So-
Actually, the only motion I was getting was, I don't know if I'm trying to basically asking for it from below that.
I'm sorry, that's not, who did that? Motion without requirement.
That's it. Okay.
And what's the length of the witnesses you intend to present, Mr. Levy?
That, Mr. Hoffman, in Canada's office, has been talking about witnesses I anticipate. Just frankly, I'm uncomfortable telling you, I mean, within the 4 hours, I don't anticipate it going beyond that. 2, and the third witness is technically Mr. Bresky, and we're working with him now to get whatever information we need to be restored to the state. But
So both sides are confident we can fit it in the remaining time on that date?
I don't know how long their testimony will be. I'm in a situation where I propose them and I don't like their testimony, so I can speak for their witnesses. I'm hoping that, based on what I'm being told, that everything
I am confident that.
All right.
Judge Mangani's office.
Hello, Melissa. On the Diamante Mole case, I just wanted to confirm that I believe it's July 27. Sorry, July 20, that we have 4 hours reserved for the conclusion of this proceeding.
Yes, it is scheduled for that afternoon.
At 1 o'clock, 1:30?
1:30 for the entire afternoon.
All right. Any other clarifications? You'll make arrangements for Mr. Jolly if he wishes to monitor or participate remotely, Mr. Simon and Ms. Horowitz? All right, and he's going to testify remotely?
Yes, that was the plan.
And there is no objection, Mr. Levy?
No.
All right. Any other details while I have my assistant on the line in order to finish the case? All right, then it remains as set for the remainder of the case.
Thank you.
All right, thank you. This matter is completed per day.
Thank you, Your Honor.
All right. Adjourn.
There's one more case on the docket, William Cordova.
Yes, there is actually. Okay, well, at this point, it's probably futile, I think. Okay. All right. So this was actually for imposition of sentence, if I recall.
Yes, that is correct, Your Honor. I believe that the defense was going to ask for a continuance.
Who is?
The defense was going to ask for that be continued for 2 to 3 months.
From today's date?
That is my understanding, Your Honor. My understanding is that it was known that the witness had provided some testimony, and that testimony has not been concluded.
All right, and the state does not object to that request?
Correct.
All right, and are you willing to address this in their absence based on apparently agreements that have been reached?
Your Honor, I'm actually, as your clerk was kind enough to advise, I'm covering for Ms. Mason. I'm actually covering for somebody else, but I didn't want to have Ms. Mason spend time with us.
Do you wish to reset it with my office arranging with Mr. Millinan to determine if there's been some confusion here?
I think that would be prudent, Your Honor.
Okay.
And if it turns out that there in fact can be a stipulation, then we'll ask Mr. Millinan to.
All right, let me just tell my assistant then.
Thank you, Your Honor.
Judge Mangani's office.
Melissa, there was one other case here, the Cordova case. That was for imposition of sentence. Mr. Millinan and Mr. Cordova were not seen today. However, Ms. Horowitz, on behalf of other assistant state attorneys, is indicating that there may be an agreement for that matter to be continued. However, given that we don't have the participants, what I'd like to do is on the court's initiative to have you reach out. And Ms. Horowitz, who would be the contact at state attorney? Would be Ms. Brumley or Ms. Mason?
It would actually be Ms. Brumley.
So Melissa, on case number 17 CF 795, if you could reach out to Ms. Brumley and Mr. Millinan and indicate that the case was called as set today at 1:30, and to see if they wish to enter into an agreement as to whether the matter will be continued or have it set for another court date to address it.
Thank you, Your Honor.
Now, I do need to give it a control date for the clerk. Melissa, would you suggest perhaps on Friday? By then, we should have reached both sides, and we should be able to know what would be occurring.
No, I wouldn't think that quickly. I would think maybe the next case management or next plea date, and then, let me see.
Well, the only concern I had was whether we were in a bench warrant situation. It doesn't appear that that's...
It doesn't, Your Honor, but we had anticipated counsel.
Right.
Defense being.
So I would like to see if you could let me give it as a control date, just for the clerk's purposes, whatever the next case management date is. Yeah, actually, I have it Thursday, don't I? Yeah, let me just set it, Melissa, let's see if they could address this at case management this Thursday. I know we've got a lot of cases, but I don't want to, this needs to be addressed as serious charges, and we need not to lose track of it.
On the 130 docket?
Right. And the parties, either side or both, can appear remotely if they wish, obviously.
I'll convey that information.
So if you'll reach out to Mr. Millinen's office as well as Ms. Rumley, I think Ms. Horowitz is going to also do that for Ms. Rumley, so.
I will contact this one.
Okay, so I think then just have Melissa reach out to Mr. Millinen then.
Yes, please, Ron.
Okay, Melissa, if you'll follow up on that, and Madam Clerk will be addressed on Thursday. All right, thank you.
Have a good afternoon.
Goodbye. Adjourned.
Off the record.